continue the arguments this morning with Litchfield Township versus Forever Blueberry Barn. Case number 18CA0023M. Each side will have 15 minutes to present their cases this morning. You may reserve up to 5 minutes for rebuttal if you choose to. We've read the briefs and are ready to proceed if you are.
Thank you, Your Honor. May it please the court, I am Tom Karras. I'm an assistant county prosecutor from Medina County, and I am representing the township of Litchfield, which is the appellant in this matter. I'd like to reserve 4 minutes for rebuttal.
Very good. I'll let you know when you get close.
Okay, thank you. The appellant is seeking a reversal of the trial court's decision that the primary use of the subject building is for the venting and selling of wine pursuant to RC 519.21A. The court erred in finding that the trial court erred in finding that the activity conducted by the appellee in the barn is primarily the venting and selling of wine because its the rental of the building for events such as weddings was the selling activity. The subject property is zoned residential. Therefore, operating a wedding venue where wedding receptions are held is prohibited in a residential zone under the Litchfield Township zoning resolution. Nonetheless, Forever Blueberry Barn, the appellee, built the barn and began renting it out for wedding receptions and other social gatherings until it was cited for a zoning violation. The appellee then claimed an agricultural exemption from the zoning, and this action was brought by the township to enforce its zoning regulations. The trial court granted a permanent injunction, at which time Forever Blueberry almost immediately thereafter moved the court to seek relief from the injunction, claiming that it was operating a winery in the subject barn. To prevail, Blueberry Barn had to show that pursuant to RC 519.21A, it was indeed cultivating grapes on the property, and its primary use of the building was the venting and selling of wine. It's as if the appellee used a checklist to make sure that it complied with each requirement under the law to qualify for the winery agricultural exemption.
Well, let's say he did use, or they did use a checklist. That's not illegal as long as you comply.
No, not in and of itself, but as I will argue, not in and of itself does a checklist. And certainly, everyone would use a checklist.
Sure.
But what we'll show is how they qualified for each of these. You know, for instance, first, it planted approximately 50 grapevines on the property, though there is no evidence that any of the grapes that were grown would be used to produce the wine, much less that even one grape was harvested. And again, Sperry v. Terry does not require, Sperry v. Terry, which is the controlling law in this matter, does not require that grapes be cultivated or that grapes be used for the wine. However, with all these other facts, it is clear that the appellee was, like I said, merely trying to qualify as minimally as possible for the checklist. So first, they planted the grapevines. Next, they applied and obtained a winery license from the Ohio Board of Liquor Control, including making labels for various types of wine it was intending on producing. Next, it set up a winemaking operation in the subject building in the back corner of the building, utilizing about 4% of the floor space. The remaining space was still set up for weddings. With the use of a home winemaking kit and grape juice obtained from other sources, it made several bottles of bottles of a nominal amount of wine from the grapes. Mr. Panuski, who's the principal of Blueberry Barn, sold 6 bottles of the wine to his cousin at $10 apiece. That was the only sale that occurred, and however, there was no evidence that the barn was utilized to consummate the sale. Ms. Panuski then testified that he would allow weddings to be held at the barn for the primary purpose to sell wine. But there was no testimony as to how much wine was required to be bought before the wedding would be held, or how much revenue it would realize from the sale of wine as opposed to the rental of the facility. Based on these facts, the court found that the primary use of the building was the venting and selling of wine, relying on its finding that wineries commonly use receptions of all types to promote their product, a finding that was not based on any testimony or other evidence that was presented to the court. Now there's a bromide that bad facts make bad law. The court found that the court stated that the floor space was not a significant factor. The fact that they only used 4% of the floor space and the rest was used for the weddings, the court didn't see as significant. Nor did the fact that no grapes were used to make the wine, nor that there was minimal production or no sales. Sperry v. Terry, unfortunately, does not address what are the elements which constitute primary use. Though it did state that the building was primarily used for winery, as a winery, the facts were not similar, and primary use was never really an issue in that case. If the trial court's decision is not overturned, the court's analysis will be precedent to define what primary use regarding the winery exemption. Like I said, bad facts make bad law. In other words, if you produce a minimum amount of wine, if you utilize your building for weddings and only use 4% for winemaking, and if you simply get a winery license, then you qualify to be a winery, and that's exemption. And again, I would assert that that's bad law, because this would be the only precedent for that in the court. Therefore, I would ask that the trial court's decision be reversed, and that it be remanded, and the decision be stricken from.
What is your thoughts on the standard of review in this case?
I'm not sure I understand your question.
What do you think the standard of review for this court is? Is it an abuse of discretion? Are we looking at the court abuse its discretion, or are we looking at this issue de novo? No, I understand, Your Honor. No, I think that it's an abuse of discretion to find that this satisfies the primary use. And you say Sperry is controlling, but you don't think it went so far as to define what a primary use of the building is, because there are some similarities, aren't they? There between the two cases.
Yeah, there are similarities. It was the issue was the real issue in Sperry v. Terry was how much grapes had to be grown and how much grapes had to be used in the making wine, and simply ruled that the grape, no matter what amount of grapes were grown on the property, that would be sufficient. And no matter how much of the grapes were used to produce the wine is of no consequence.
Are you challenging whether or not this is an agricultural use, this property?
Yes, we are, Your Honor. We don't feel that it is an agricultural use, and they're not entitled to the exemption.
So the finding that this is primarily used for the venting and selling of wine, it just has to be used for viticulture, for the venting of wine. There do not have to be any wine sales. It's just that the court found that the other proposed use, the wedding reception, was the selling of the wine.
Yeah, no, there is a requirement of minting and selling as far as the use of the building, not as far as the use of the property. But there is a sales element in the statute itself. And the problem is that when they're using 96% of the property, and there was evidence that was testified that it was still set up for weddings, that 96% of the building itself was still set up for weddings, and there was no evidence to say that other than Mr. Pinewski testified that, oh, before I have a wedding, they're going to have to buy wine. Well, how much wine? One bottle of wine? And then charge them, there was testimony prior that he was charging anywhere from $3,000 to $4,000 a night to rent the building. Well, if he was going to make up that revenue with wine sales, even at $10 a bottle, as he sold to his cousin, that would require a buyer to buy 3,000 to 4,000 bottles of wine.
But obviously there's no zoning issue if I'm just making wine for myself and I'm not selling it.
No.
Okay. So
No, the problem is this isn't a residential area. If it was in a commercial area, that certainly they could have a venue. That's within the code. But this is right in a residential area, and there's this huge barn where they have wedding receptions up to 200 people.
But at the time, because of the injunctions, they were not having any wedding receptions.
Well, yeah, they were precluded.
just had a building.
They did have, the first year they did have approximately 12 to 14 weddings. And then they were precluded by the injunction. But since then, it's my understanding that there haven't been any weddings.
And so I have a follow-up question on this. The trial court maintaining jurisdiction after issuing the permanent injunction?
It did, Your Honor.
So when we see the record, is it going to be the whole record of everything, or is it just going to be what happened since the
No.
filing of the request to lift the injunction?
No, I believe you'll see the whole record. That I submitted the whole record for your.
You have 3 minutes left for your rebuttal.
Okay, thank you.
Council, you have 15 minutes.
Thank you. May it please the court, my name is Michael Larrabee and I represent the appellee Forever Blueberry Barn. It's our position that the trial court was correct in its journal entry stating that the Litchfield Township has no zoning authority over Blueberry Barn's use of its barn to vent and sell wine on its property. It meets the viticulture exception of Revised Code 51921A. It is engaged in viticulture on the property, and the barn building is used primarily for venting and selling wine. Litchfield argues that Blueberry Barn does not meet that exception, and basically that its winery operation is a sham, and that the barn is not primarily used for venting and selling wine. Respectfully, Litchfield Township misstates and mischaracterizes the facts, minimizes the facts that were presented to the trial court. Even at the initial injunction hearing in 2015, Blueberry Barn presented evidence that it was in the process of becoming a winery. The injunction of January 2016 recognized that fact and said that the court would address that issue at some future time if they became a winery. In March of 2016, Blueberry Barn moved the court to terminate the injunction based upon the fact that it met the viticulture exceptions, or the exemption. I'd first like to address the argument that Litchfield is stating that Blueberry Barn's operation is basically a sham, the winery.
Well, let me start off by asking you a question in regard to that. So they were operating as a wedding venue,
Correct.
and then when the zoning commission or whoever with the township then got the injunction, then they started doing, were they doing the viticulture before that, or was there?
They had started their application for the winery permits and so forth. They prepared, and that had already been filed by the time that the injunction.
But they had not opened with a permit to run a viticulture.
That's
They were
correct.
running a wedding venue to begin with.
Correct.
Okay, and then they decided to run a viticulture.
Correct.
Okay. If we have the entire file with the hearing and everything, and it took $3,000, they would make $3,000 to $4,000 on the wedding venue, that would be 300 to 400 bottles of wine they'd have to sell, which would be anywhere from 36,000 to 48,000 a year if they even just have 12 weddings. From what I'm reading in both briefs, there's just nothing there to indicate that they have that capacity or anything else.
Well, they're getting to that point, and we'll argue, I'll argue later, that the winery at the very beginning stages, obviously, they just planted their wine, their grapes. They're allowed to bring in other sources for the grape wine, to make the grape wine, and they're trying to get to the point where they would be able to establish and be able to support that kind of number. The testimony that was presented to the court was that the operators would sit down with the people that wanted to have a wine event, and they would discuss the amount of wine that they would have to purchase, and they would have to decide which kind of wine and what quantities at that point in time. So because of the injunction, they hadn't even gotten the plan off the ground.
But
to
I
do
guess
that.
I'm still thinking, so if we affirmed the trial court, you could start doing wedding events again, you could start doing whatever events again.
Well, the events would be subject to the purchase of wine.
Well, I
It would be
understand that.
tied to the sale of the wine.
I understand that, but at this point, how many bottles of wine do you have? What was in the hearing, 60-some bottles of wine?
At the time of the hearing, we had, I think it was 144 bottles of wine that had been produced, 12
In-house.
cases at the time. That was 2 years ago. That's what's in the record. So to address the issue of the evidence of the winery operation, they purchased and planted the 50 grapevines. 25 more were ordered at the time. They purchased the venting equipment. They obtained a basic permit from the U.S. Department of Tobacco, Treasury, and Alcohol, Tobacco, and Trade. They obtained 3 certificates for their label approvals from the U.S. Department of Treasury. They obtained the product registration from the Ohio Division of Liquor Control. They deposited a wine bond with the U.S. Department of Treasury, and they obtained an A2 liquor permit from the Ohio Division of Liquor Control, which indicated that the wine may be sold and consumed inside the entire barn area, as well as the side lots and the rear lots of the property, or sold in sealed containers for off-premises.
How was that liquor permit different than the liquor permit they had to operate the wedding venue?
They didn't have a liquor permit before.
So they were operating a wedding venue without a liquor permit?
Correct. That's correct. As I understand the testimony. Yes, I think the people would bring their own alcohol at that time. It was not sold to them. They didn't have any.
They allowed
ability
people to
sell.
bring alcohol, their own alcohol?
I believe that's how it was structured. I believe that was the testimony, because it's a private venue.
Opposing counsel said they were using homemade, home winemaking.
That's not the testimony that was presented.
That's not the equipment that was purchased.
No, it wasn't a home wine kit. It was a vast amount of, they call it carboys, fermenters, all the equipment. It's in the testimony that was presented, what they purchased to the wine. Certainly, they could supplement, purchase more equipment as they went along, but it wasn't a home wine kit by any means.
Well, I want to go back, this is an ongoing business that they want to make profit off of.
Correct.
Okay, but yet I guess through the testimony, I'm understanding that they didn't have a business plan, they didn't know how many bottles they'd have to sell in order to have a successful event, they'd have to make a profit. Doesn't sound like they have any idea about any of that.
At the time of the hearing, the testimony was that they would sit down with the people that were interested in an event, and they would decide how many people were coming, and they would come up with a plan as to the amount of the wine that would have to be purchased and the amount of each bottle of wine at that time.
Well, I understand, but you don't even know at that point whether you'll be able to sell 2 bottles or 10 bottles or
That's true.
150.
That's true, but I don't think that the review is how much wine they sell.
No, but it is whether or not they're legitimately and substantially operating a viticulture. And if that involves the sale and the making of wine, or are they running a wedding venue?
Understand, but there's nothing in Terry versus Sperry which talks about the primary use as a percentage or the square footage or the amount of wine that has to be sold. It's, if you operate a viticulture on the property, the structure that you're using, you would be able to, is primarily used for the sale, the venting and sale of wine, then the zoning would not apply. It doesn't talk about the number of wine bottles that have to be sold per event. It doesn't talk about how many wine, grape
But did they
vines
have,
would have to
I
be
don't,
grown.
in Terry, was there events?
Is a restaurant. Is
There's
a
a
restaurant, there's a restaurant in a residential area, and I will get to that, certainly.
Well, that's a little different though, isn't it?
I don't believe so. I think it's probably worse. You have a restaurant in a residential area. The primary use is not the sale of wine in a restaurant. The primary use of a restaurant is to sell food.
Well, that brings me to the earlier question about venting and selling. You could vent, obviously. Then if you had a place off premises that you sold it, would it still, it would still be covered under the exemption, right?
Correct.
Even though the finding is venting and selling versus venting, obviously, or selling wouldn't work, it was just selling.
Correct.
Okay. So when you're talking about primary use, it could just be venting, right?
It could be.
Okay. The selling comes in when you're talking about the operation of the wedding reception. Am I correct in that?
That's correct. Yes.
But to follow up on your question, so I understand it, the point is you don't want to just vent wine there. You want to have wedding receptions there too.
It's not necessarily wedding receptions, it's any kind of gatherings. It's any kind of corporate events, it's any kind of birthdays, any events.
And you wouldn't be able to do that unless you could demonstrate that you're selling the wine there.
Correct. Well, no, I mean, we wouldn't be able to meet the viticulture exception unless we were selling, you're using the barn.
That's what I'm
to sell.
saying.
Correct, that's correct, yes. We asked the court to approach this case with two principles in mind. Number one, restrictions on the use of property by ordinance or statute must be strictly construed, and also exemptions from restricted zoning must be liberally construed. So the Supreme Court in Terry versus Berry unanimously held that if there's agricultural use on the property in terms of viticulture, the township may not regulate the zoning of buildings that are primarily used for venting and selling wine. Further, there's no requirement that the venting and selling of wine must be secondary or subordinate use, or that the viticulture be the primary use of the property. Even though a winery itself does not constitute an agricultural use, by the general definition of agriculture, it can be nevertheless be exempt under the viticulture exception. So going to your question, Judge Theodosio, the Terry versus Berry, the comparisons and so forth. So Milton Township and Terry versus Berry, they sought to prohibit the Sperry's from the use of the property as a retail winery and restaurant in a residentially zoned district. The Sperry's obtained federal and state permits to operate a winery, and the property itself contained only 20 grapevines, of which only 12 were harvested. And the Sperry's obtained grapes and grape juice from other sources for its wine. Only 5% of the sales of bottled wine were sold at the winery were from grapes planted or cultivated on the property. So the facts are very similar to the case at Barr. Both seek to use the property for venting and sale of wine in a residentially zoned district. Both obtained all required federal and state permits. Both engaged in viticulture on the property. However, Blueberry Barn has planted more than twice the number of grapevines on his property. And both obtained grapes and grape juice from outside sources. Terry versus Berry stated that the statute does not establish a minimum number of vines needed for cultivation or to constitute viticulture. Both the court and the legislature declined to establish a minimum amount of vines or grape production that would otherwise require in a viticulture operation. Both declined to apply a space use analysis to determine the primary use of the structure. Both declined to establish a particular method of sale. And the legislature could have, if it chose to, define primary in its statute as it did in the farm market exception. If you look at 519.21c, which requires farm markets to have more than 50% of its gross income from produce raised on farms owned by the farm market operator, and it chose not to do that in this case. Addressing Litchfield's four arguments, number one is they argue that there's only a small portion of less than 5% of the floor space is used to produce wine. Our position is that the appellant mischaracterizes the testimony. The entire barn is used exclusively for venting and selling wine. The liquor permit states that the wine may be sold and consumed inside the entire barn building, as well as the side and rear lots.
So the
we're-
5% you're saying is really only for the venting?
No, I'm saying the 5% is some sort of an anomaly. Actually, they're saying 4%. Where does it come from? The Litchfield inspector testified that on the date of his inspection, he went and he measured the area where the equipment was actually located that day, and then he calculated it as being 4% of the entire barn building. But on cross-examination, he conceded that the Blueberry Barn was not engaged in mitigation in venting at the time, and other areas could be used for venting. He also conceded that no one showed him where the actual venting occurred. At the time, it was just stored in one area near the kitchen. He merely assumed that that's where all the venting took place, where it was located that day. Furthermore, the evidence was clear that the venting equipment, all of it is located within the barn building in different areas. Blueberry Barn keeps their storage areas and closets and so forth when not actively venting. They manufacture all of the wine in the barn building, and it stores its bottled wine in bottled or bonded areas as required by the permit, the liquor permit. We can also look at Shabel versus Troyan, which is a 11th district case, which dealt with the same issue. In this case, it was a pavilion at a winery, which was used for wine tasting, and the 11th district said it was exempt as an agricultural use. The pavilion in that case was used for wine tasting and entertainment. It contained tables and benches for customers to enjoy the wine there. And the township, the court said the township was not entitled to rely on the owner's past uses of the pavilion as charitable events or other family gatherings to argue that the pavilion was not used properly for the winery. And again, the Supreme Court and the legislature declined to apply a space use analysis to determine the use of primary, or the term primary use of the structure. Second, the Litchfield argues that there's no evidence that wine was produced, that wine produced is sold on the premises. This is simply untrue and premature. Blueberry Barn presented evidence that it sold 6 bottles of wine, but it also presented evidence that it refrained from selling its wine through receptions because of the injunction. So it held off on planning its open houses and other events because it did not want to be held in violation of the
Got about a
injunction.
minute left.
Okay, thank you. Third, they argued that the primary use is basically a wedding venue. The evidence is clear that the revenues will come from not rental fees, but generated from the sale of wine during receptions. The barn building will be used as a marketing tool to sell the wine. The testimony was clear that there would be no event where Blueberry Barn didn't sell the wine, didn't sell wine at the barn, and all wine sold in the barn would be vented in the barn. Again, the Supreme Court and the legislature declined to require any special methods of wine sales to qualify for the viticulture exception. The last argument that Litchfield had is that the grape wine produced was not made on the property. Well, it takes time for grapes to grow and produce fruit. At the time of trial, the grapes were just beginning to grow. It is the Blueberry Barn's intention and goal to produce fruit on the property to support all of its winery operation, although this is not required by Terry versus Perry. In conclusion, we think that by strictly construing the zoning ordinance and liberally construing the viticulture exception, the trial court properly concluded that Litchfield has no zoning authority over Blueberry Barn's use of its barn to vent and sell its wine on its property as it uses the property for viticulture. We ask that Litchfield's assignment of error be overruled and the judgment of the trial court affirmed in all respects.
Standard of review, in your opinion?
I believe it's abuse of discretion.
All right, very good, thank you.
Thank you.
Here's 3 minutes.
Thank you. Judge Hensel, to answer your question regarding whether the selling of wine in the facility, in the building, is required under 519.21, we believe that it is required, that some sort of selling activity must occur within the building for it to have the objection. The structure of the sentence says that the primary use of the building has to be for the venting and selling of wine.
Yeah, I see that.
Okay.
Yet if you're not selling it, I don't know how you end up being in violation of the zoning code to begin with, so that gives me pause. Do you understand? Because it's.
Okay, I understand. However, no, however, it's not the venting of the wine that is the violation. It's the conducting of weddings that is the violation of the zoning. Anyone is free to make wine in their homes and without violating the Litchfield zoning. However, if they have parties for hire, or they sell their wine, or they have their wine and they have parties to drink the wine, we believe that is a violation of the Litchfield zoning and contra to 519.2. Thank you. We ask that the decision of the trial court be reversed. Thank you.
All right, thank you both for your presentations today. The court will take the matter under advisement and issue a decision. Clerk of Courts will mail you a copy of the court's decision when it is released, and the opinions are also posted on the Supreme Court of Ohio's website, so you can keep an eye out there. Thank you both again.
Thank you.